The top 10 legal mistakes that entrepreneurs make. Number 10, not considering international IP protection. At the earliest stages of your company, you should already be considering protecting your intellectual property overseas. Patents, for example, are decided on a country-by-country basis, and while in the United States there's a 1-year grace period between when you disclose an invention or sell an invention and when you can patent it, other countries you need to have a patent already before you ever sell the product or ever tell anybody about it. So if you launch your product in the United States and you end up selling overseas, you might lose the ability to patent that product overseas. This could be detrimental to your company, especially if it's a high-tech company that's relying on patents and innovations. Trademarks are the same. You might get a trademark in the US, but if another company is able to get that trademark registered overseas, you won't be able to use your own brand overseas. So make sure that at the early stage of the company, you're already considering how to protect your intellectual property overseas. Number 9 is starting your company while employed by a future competitor. Most companies will have clauses in their employment agreements which say that you're not allowed to start a competitor or sometimes any business at all. On the extreme end, you might have a non-compete clause. This will say that you're not allowed to start a business which is competitive with your employer, either while you're working for them or for a few years afterwards. You also have a non-disclosure agreement, which will prevent you from using information gained at the company, including trade secrets, to start your competitor. Finally, you could have something like an intellectual property assignment agreement, which says that all the intellectual property that you develop while you work for the company is actually owned by the company. If you're in a management position, this could sometimes mean that things that you would develop while you're living at home or working at home are actually owned by the company, especially if the company expects you to work outside of the standard 9 to 5 hours. It's also important to consider all of this when hiring people. You don't want to hire someone who's bound by a non-compete or non-disclosure, and then their former employer comes in and sues you when you launch a product. Number 8 is boosting the figures in your pitch deck. While I know this may seem like a common practice in a lot of Silicon Valley, and investors love to see that large total addressable market or that hockey stick-like growth, the truth is that your pitch deck is an investment document, and fudging the numbers in it can amount to a crime, at the very least can be fraud, and your investors would have the right to sue you for the money that they've invested. It's important to remember that your pitch deck is trying to sell the shares in your company. It's meant to represent the current state of your company and where you think your company can go. If these are lies, you're probably committing some sort of securities fraud, and you could actually be in a lot of legal danger. Now let's be honest, we know that this doesn't often amount to any legal issue, but at the very least, you're going to ruin your credibility, both with investors and potentially with your consumers. So try to avoid fudging those numbers in your pitch deck, try to be as honest and transparent as you can. You'll both avoid legal issues and gain better relationships with investors and with the community as a whole. Number 7, not using non-disclosure agreements. Disclosing inventions without proper protection can be a costly mistake. In many countries, if you disclose an invention without having a non-disclosure agreement in place before you file for a patent, then you will not be allowed to ever file a patent for that invention since you already shared it with the public. If a patent isn't available in your scenario, then the only way to protect your invention is to maintain it as a trade secret. To do so, you also need to have had non-disclosure agreements in place every time you shared that trade secret, or else the courts won't consider it a secret. When dealing with investors, many of them are going to refuse to sign non-disclosure agreements, so you need to work with ones that have a good reputation and make sure that your business plans and pitch decks include a statement on the cover page that says that they're confidential and proprietary. This isn't as strong as a non-disclosure, but in many states, it will bind them to the same restrictions. Make sure to protect your intellectual property. It's a key part of startup success. Number 6, prioritizing valuation when negotiating venture capital deals. It's important to be aware of all the factors that come into play when negotiating a venture capital deal. While valuation is an important consideration, it's not the only thing to consider. Venture capitalists have many ways of getting compensated, even if they end up paying a higher price for shares. For example, they may require participating preference shares with a high cumulative dividend. This means that you're paying them a large amount every single year. They could have redemption rights exercisable after only a few years, which means you might have to buy them out after a couple years. They could also have a ratchet anti-dilution protection with no cap, which means that in the future, they could get free shares from you. It's important to consider all of these factors when you're considering a venture capital deal to accept. In addition, you also need to look at the reputation of the venture capitalists and look at whether or not they might have follow-on funding. It's important that when you negotiate a deal, you take a holistic approach, don't focus on valuation. Number 5, using a lawyer without experience with startups. Choosing the right lawyer is an important decision for any entrepreneur, and it's crucial to make sure that your legal counsel has the right experience and expertise. Hiring a lawyer who isn't experienced in dealing with entrepreneurs and venture capitalists can be a costly mistake. Many VCs consider the choice of legal counsel to be an important factor in assessing the judgment of entrepreneurs. Lawyers who don't have experience working with entrepreneurs and VCs may not be aware of the unique challenges and opportunities that come with starting and growing a business. This can lead to them focusing on the wrong things and failing to recognize potential traps. When choosing a lawyer, it's important to find someone who has experience working with entrepreneurs and VCs, someone who knows how to play the game, and who understands the challenges that you're going to face. Remember, VCs are going to judge you based off who you pick as your counsel, especially when negotiating against them. So pick someone with a good reputation who you can trust. Number 4, spending hours trying to compile legal templates online. As a founder, it is important to keep your costs under control, and you need to use your resources wisely. However, when it comes to legal documents, trying to cut corners can be a costly mistake. It's true that founders do not need to spend thousands of dollars for a lawyer to draft a simple contract. However, trying to compile templates online can be a waste of time and may not provide you with the legal protection that you need. Instead, consider paying for a SaaS service, which will provide a quality online template, one you don't need to mess around with, and will give you 90% of the value of a lawyer at maybe 5 to 10% of the cost. Look at sites like $1contract.com or Law for Startups. These are great resources to help you save costs on the legal side without wasting hours online or potentially using something that won't actually provide the legal protection you're hoping for. Number 3 is issuing founder shares without a vesting schedule. Issuing founder shares without vesting means that each founder owns a certain percentage of the company right away from the start. This can create problems if one or more of the founders decides to leave the company. Without vesting, the departing founder will still retain a percentage ownership in the company even if they're no longer contributing to the company's success. Vesting is a way to protect the members of the founding team who actually decide to stick with the company and take it forward. The idea is very simple. If people remain on the team and they're productive, their shares vest, and over time they get greater ownership of the company. If they leave, then that stock can be recuperated by the company, given to whoever's brought on to replace them, or shared amongst the remaining founders. Vesting protects the company's interest, it protects all founding members who stay with the company, and overall will be appreciated by investors who don't need to worry about dead equity on a cap table. Number 2, failing to incorporate early enough. Failing to incorporate early could be a costly mistake for you and your business. There's many problems that can arise from a failure to incorporate, and here are a few of the biggest ones. Number 1, you can incur personal liability. When you're incorporated, if your company incurs a debt or gets sued, the most you can lose is your investment in the business. If you aren't incorporated, then creditors can come after your home, your car, and other personal assets. Number 2 is the risk of a forgotten founder. This can happen when a partner involved in starting the business drops out and the venture subsequently gets incorporated. The partner can then return and sue for equity, arguing that they would have had shares had the company been incorporated earlier. Number 3 is that you can mess up your IP assignments. If you create IP before the company is incorporated, that IP might not actually be owned by the company, and this can make it difficult sometimes to raise funding from venture capitalists and other investors. Number 1, thinking that legal problems can be dealt with later. Startup founders often believe that they can delay dealing with legal issues until they've secured funding or increased their revenues. This is a very short-sighted approach. Many legal problems can't be effectively patched up later, and one of the biggest reasons that startups fail to raise money is because they have a legal problem that has existed from the time they started that they never dealt with. Another thing you're not considering is that neglecting legal compliance can hurt your reputation and relationship with partners, customers, and investors. If you don't have the proper contracts and agreements in place, it can cause misunderstandings and disputes. It can make you untrustworthy. So what's the bottom line? When it comes to legal compliance, you need to avoid the temptation to delay addressing legal issues. You do not need to spend thousands on a lawyer, but you do need to invest a little bit of time and money, whether that's buying a legal course, watching YouTube videos, educate yourself, and you'll save yourself money and headaches down the line.